certainly encourage you to consider joining us. I think you'll find a membership brochure amongst all the paperwork in your seat. There are many benefits to membership, some of which are outlined there. But even if you don't decide to become a member today, I highly encourage you to consider, if you have an ongoing interest in the field of international law broadly, to come to our annual meeting, which will be at the end of March here in D.C., March 24th through 27th, I believe, at the Ritz-Carlton nearby. That will be 4 days, chock full of panel discussions, keynote addresses, and debates on a wide variety of topics within the field of international law. So it's a pretty intellectually rich program. So I do encourage you to consider to come to that. With that, I don't want to take up any more time on the program today. I want to introduce to you Dick Jackson, who is the secretary of the Lieber Society, and he's going to make the introductions from here. So, Dick.
Thank you, Sheila. The Lieber Society is very pleased, too, to present this program today. The Lieber Society's purpose is to disseminate and further the understanding of the law of armed conflict. It's named after Francis Lieber, who wrote the Lieber Code, really the first codification of the law of armed conflict circa 1862, that really was the founding of the law of armed conflict of the modern day. In fact, many of the provisions of the Lieber Code are still extant, and you'll notice pieces of them in the Air and Missile Warfare Manual. The Air and Missile Warfare Manual is a product of the Alabama process, which Professor Bruderlein will explain to you in a little bit here, but it's been commissioned by states and the ICRC to illuminate this vital area of international law. The manual is a monumental project which should help provide some clarity to the existing law in this area. As Professor Bruderlein will explain, the project actively sought input from states and government experts and governments around the world. The HPCR should be commended for its excellent product. But one of the questions for the commentators really will be, who I'll introduce in a minute, is this manual lex lata or lex ferenda? That's a phrase that Jorm Dinstein, one of the principal authors of the commentary, has used several times in talking about the development of international law in this day and age. Is it a restatement of the law as it exists, or the law as its authors wish it to be? First, I'd like to introduce the speakers, and then Professor Bruderlein will have about a half an hour to provide an overview of the Air and Missile Warfare Manual and delve into some of its terms. And then Professor Kenneth Anderson will give us about 15 minutes talking about the black letter rules and his view commenting on those rules. At which we'll turn it over to Admiral retired Jane Dalton, who will talk about the commentary, principally, that has not yet been published, but that Admiral Dalton and many government experts provided input to. Professor Bruderlein is the director of the program on humanitarian policy and conflict research at Harvard University, as well as the president of HPCR International, based in Brussels. And there's some materials about HPCR out on the table, so afterwards I encourage you to pick up those materials. They also provided a copy of the Air and Missile Warfare Manual black letter rules for each of you. Professor Bruderlein has been engaged in international humanitarian protection since 1985. He obtained a BA in economics from McGill University in Montreal, Canada, and was granted a law degree from the University of Geneva. He then served with the International Committee of the Red Cross all over the world as a delegate in armed conflict and in specific places where the ICRC was working, including Saudi Arabia, Kuwait, Yemen, Israel, and the occupied territories. In 1996, Mr. Bruderlein received a master's degree in law from Harvard Law School and was admitted to the New York Bar. That same year, he joined the United Nations and provided advice as a special advisor on humanitarian affairs. In 2001, he was appointed lecturer at Harvard School of Public Health, where he co-directs the master's program in global health. As co-chair of the Alabama process since its inception in 2003, he's contributed to the development of several research initiatives on humanitarian law, the most recent of which is the Air and Missile Warfare Manual. Professor Kenneth Anderson is a professor of law at Washington College of Law, American University, and a fellow with the Hoover Institution Task Force on National Security Law. He's written extensively on the laws and ethics of war, serving as legal editor of the first edition of the book Crimes of War, and in 2009 was a member of the Department of Defense peer review panel on the draft Law of War Manual. And incidentally, Ken is also a officer of the Lieber Society, serving as our outgoing treasurer. Rear Admiral retired Jane Dalton served 28 years in the U.S. Navy, 8 years as a line officer and 20 years as a judge advocate. She was the Charles H. Stockton Professor of International Law at the United States Naval War College, which is really the premier post within the military education system for international law and the law of armed conflict. She was, from 2005-2006, she was in that chair, then served as an attorney advisor, international law, in Department of State from 2006 to 2008. She's been a professor and lecturer at George Washington University Elliott School of International Affairs, and since the fall semester 2007 has provided contract support to the Department of State on Arms and Export Control Act issues and defense trade issues. She earned her JD from Georgetown University Law Center in 1985 and a Master of Laws from the University of Virginia in 1992. She served in a number of significant legal positions within the Department of the Navy, culminating really in the legal advisor, the chairman of the Joint Chiefs of Staff, and is truly an expert in the area of the law that we're talking about today. So with no further ado, I'd like to turn it over to Professor Bruderlein.
Okay, very good. Well, good afternoon. I'd like to thank you for coming this afternoon to look into this major project of HPCR on international law applicable to air missile warfare. I take this opportunity to thank the American Society of International Law and the Lieber Society for their invitation to present the manual here in Washington. And I'm also very pleased to share this panel with Ken Anderson, who incidentally, I'm sure he doesn't remember it, but when I was a young lawyer, I saw him on a visit in New York when he worked at the Open Society, and he played an important role in orienting my career in the US, telling me I should do an LLM. And Jane Dalton, who has accompanied this process for a number of years, participating into the group of experts on AMW. So we have here an excellent panel to discuss the project, and I would like here to give you enough background to participate in this discussion. Evidently, 5 years of work cannot be summarized in half an hour. What I'd like to do here is to give you, as an introduction on the origin and the method of the project, because this is really a topic of interest in an environment where the development of international law in a positive sense is being put into questions, and there is different avenue being explored by organizations such as the ICRC or international courts in looking into ways of further strengthening the legal discourse and looking into the evolution of methods of warfare. And then I will point to some of the articles into the manual to illustrate some of the debates that took place during this process. So to start, very few words about HPCR. HPCR is based at Harvard University in terms of research and policy. It's a project that will celebrate its 10th anniversary this year. It is a multidisciplinary endeavor working on humanitarian law from both a legal and a public health perspective. It also maintains close link with the Kennedy School and other schools at Harvard University. And HPCR International, which is a training and a conference organizer based in Brussels. The activities of HPCR are essentially about conducting research and developing policy inputs that is participating in existing policy processes within governments or among governments within the United Nations, try to expand the imaginary space, as we say, of policymakers, bringing them to think about alternative ways and method of engaging on issues such as transnational armed groups, high-tech warfare, multinational operations, etc. It developed online platforms, both as reference sources and platform for exchanges. You may have heard, or some of you may take part to the live web seminar that takes place on a monthly basis, broadcasted from Harvard University. There's some information and a flyer on this activity. We had one broadcasted from Washington earlier this week on private security contractors, and our next session is on transitional justice later in February. And finally, hosting informal dialogues and advanced trainings across the world to address some of the most salient challenges in the protection of civilians. My colleague Anahi Nahikian, that is here, and myself are available if you have any further questions on HPCR. Now, about the air missile project, as Dick Jackson said, this project emanates from what we call the Alabama process. That is an informal consultation among governments on what are the main challenges to the implementation of international humanitarian law. And in January 2003, at a conference in Massachusetts, this group of 30, well, there was about 70 experts from 30 states, recognized that high-tech warfare, and particularly air warfare, was a real challenge to the implementation of international law, particularly because the Geneva Conventions and other treaties mostly apply to land warfare or sea warfare, and it's only by interpretation they apply to air warfare. Therefore, it was seen that a consolidation of these interpretations was could be a good asset to facilitate the implementation of international law in air warfare. The last time that such an effort took place was 1923, so you can imagine the type of air warfare that took place at that time. So significant technological evolution, especially questioning the dimension of the battlefield, questioning the capability of belligerents to engage in hostilities in remote locations, and all the appreciation vis-a-vis strategic bombing and issue of proportionality, etc., ending with 9/11 with the use of civilian airliner as a weapon. So all this accumulation of experience dictated new attention to air warfare. Following the first informal high-level expert meeting at Harvard, the project was launched in January 2004, based on the model of the San Remo Manual on Naval Warfare. So we were extremely lucky to have a model to look into, because to start such a process of interpretation, where we bring eminent experts from around the world and look into state practice, is a real challenge. I must say, 5 years into this process, I feel the manual will be officially launched in Brussels on 4th of March. It's the feeling of a very long pregnancy. And all the anxiety about, are we going to get to the end of it? What name it should have? Oh, I tell you, just the name of the manual took weeks and weeks of discussions. So that's not to say every detail of the black letter rule and then as it was reflected into the commentary. I mean, this project mobilized enormous amount of energy, intellectual, financial resources that cannot be underestimated for anyone who wants to do the same. So that is to say, there was 3 phases to the project. First phase that lasted 2 years was the identification of what are the legal areas and topics in which we would benefit from a manual on air missile warfare. And these areas are actually reflected in the outline of the manual you have there. And they are mostly the ones that were identified in January 2004 when we started the process. Then there was a second phase based on a research paper produced by the expert participating in this process, meeting in January 2004, and then every 6 months, experts were asked to produce a paper on that specific issue, identifying the existing law of air missile warfare. And finally, so phase 2 was collecting these papers and starting to draft the black letter rules that have been distributed to you. And phase 3 is the production of the commentary. That is explaining the process and the discussion that took place while the manual was developed. Now, an important point I'd like to make here is this manual is a reflection of international law applicable to air missile warfare. It is not the international law applicable to air missile warfare. And I'd like to explain the distinction here. We have international law, international treaties, decisions of tribunal, international customs that are the sources of international law applicable to warfare and air warfare in particular. The exercise here was driven by the sense of that we need to bring a group of experts to reflect on the existing status of this international law applicable to air missile warfare. So the authority of these rules is linked to the authority of the experts who participated to this process. This is a tool that collect, amalgamate the applicable laws, especially as they come from different sources, being international humanitarian law or LOAC treaties, being international civil aviation treaties. There's different sources that were brought to the manual, and it's there to inform practitioners about the international legal status of the international legal situation, enriched by the commentary that will be published next month. I'll go quickly on this point. As I said, we had 25 topics selected in January 2004, and then the group met every 6 months in different locations, hammering these issues. The composition of the group was very delicate because it was important for the legitimacy of this exercise that not only we have the most authoritative in the room, but also a representation of different vision of international humanitarian law. Therefore, we had representatives from the ICRC, from governments, we had legal scholars. So the composition, and we had some participants from the South, we have a participant from China. We tried to get participants from Russia, but were unsuccessful. Later on, we could catch up with the Russian Federation with consultation with governments, but that is the creation of the group was a particular exercise that we were very attentive to. And this group met, as I said, regularly up to the creation of the first draft of the manual in 2006. This manual was then presented to governments. Again, as part of the Alabama process, this manual was discussed with governments and were given the opportunity to give their first response and to guide the efforts of this group of experts. One of the important points of this consultation was right early in this consultation process is where governments disagree with the group of experts in the scope of the manual. The manual was developed for international armed conflict, because for most of the experts, this is where the law is. The law of international armed conflict is the most elaborated one. And the extension of the scope to non-international armed conflict created a lot of problems for the experts to agree or disagree, particularly as it pertains to debate on additional Protocol 2, interpretation of Article 3, etc. States disagree with that. Government says it has to apply both to international and non-international armed conflict to be, in fact, a useful tool for our military. We went into consultation with governments, and this consultation fed back into the group of experts. There was a number of further meetings that allowed the expansion of the commentary. We had a drafting committee that looked into explaining each of the rules and explaining the various interpretation and perspectives in each of the rules. And as you will see, it will be put online on 4th of March. I really encourage all those who are interested by this field to look into the manual, because it's one of the best, I would say, explanation of international humanitarian law. It explicates the issue of proportionality, the challenge of precautionary measures. What do we mean by feasibility? I mean, the core essential debates of international humanitarian law are being explained and updated, as well as presenting the limitation of the current consensus. And it has been one of the, let's say, challenge of the process is that we had to look straight into the eyes of the limits to the consensus. There is this sense in the legal community, in the humanitarian community, that along to the universal values of international humanitarian law, we have a universal consensus on its mission, purpose, and content. While if we look into the details, especially at the technical level, we realize very quickly that this universality discourse is being seriously put into question when we start to look, the devils into the details. So we've been dancing with the devils for 5 years, trying to size up where actually we have disagreement, and equally, where do we have agreement within this community. And these deliberations have taken place among a group of experts who on many points disagree, but would respect the opinion of the others. And we're working together to find the right formulation to explain both the agreement and the disagreement. So it is an impressive effort that was invested in clarifying the current content of international humanitarian law applicable to MSI warfare and identifying the limitation of the consensus about these interpretations. So allow me to move forward, because I've explained many of these points in these slides, to emphasize that once we had a complete draft, we went around consulting with governments, and we had both regional and bilateral meetings with governments. Regional meeting in Australia with a number of Asian and Southeast Asian participants. We had further meetings in Namibia for Africa, regional consultation for the Americas in Canada, with NATO. That is, we went around the world collecting more and more comments and critique, trying to get it right and integrate especially the perspective of pilots. And I'll do a very short parenthesis here, because sometimes it was really impressive. The group of experts had a consensus that at the end of the day, the one who pulls the trigger is accountable for violation of humanitarian law. And then we had some pilots, F-16 pilots, coming and challenging the group of experts, saying this traditional vision of pulling the trigger doesn't apply to air warfare. And we say, what are you talking about? At the end of the day, you pull the trigger, you're responsible for the consequences, both human and legal. This is good. We will invite you to a targeting exercise, and you will see what we mean by the pilot not actually being responsible for the attack on the target. So we were invited in Brussels on a NATO base, where we followed the whole process of identification of target, of planning, of loading the data on a computer. And then they brought us somewhere in the forest of Belgium for a real live targeting exercise with 6 F-16 flying over our head. And they were supposed to target a minivan, which was, I tell you, where the window is, okay? Which is pretty close, okay? Were you there, Jane? You were not there, okay? And then you have this 6 F-16 coming, bombing with fake missile, but even a fake missile makes a lot of noise, a minivan that was just near us. And all the explanation associated to it, that in fact the pilot is not the one pulling the trigger. The computer is pulling the trigger. The computer asks the authorization to the pilot, and the pilot only verifies that the computer is functioning well. But all the selection of target, the identification, the visual contact is not in the hands of the pilot. And therefore the pilot argued, we're not responsible for the violation of international humanitarian law that may happen if we have civilians in that minivan. So that is to say, it was an interesting test for the group of experts, a reality check that has a lot of influence in the manual you have there. So some key feature, and Dick mentioned it, the distinction between lex lata and lex ferenda. Despite the strong temptation of some of the experts, the manual that you have in front of your eyes is not improving upon international law applicable to air missile warfare. It aims to clarify, it aims to make it more accessible, it aims to enrich the discussion, but each and every time, one expert would say, but actually, why don't we say, you know, that's how a pilot can surrender? Well, there was other experts saying, excuse me, yeah, that sounds very smart, but can you tell us where in state practice or international treaties we have this rule? So our feet were kept to the fire repeatedly by experts saying, we are not here to develop international law, we're here to reflect international law, and this purpose of the project was central from the beginning to the end. The second point is that international law is applicable equally to international armed conflict and non-international armed conflict, and the commentary identifies the rules that are applicable in non-international armed conflict. And then we have integrated references to other sources of international law that purely LOAC treaties. Now, what I'd like to do here is to, you know, since we don't want to be intimidated by a text, is to give you some examples of some of the rules and some of the debate that took place in these rules. You have here the sections of the manual, and I would say there's essentially three important structures. The first one is the definition. We have a first section that defines many of the terms that are being used in the manual. We came to regret many times to write this definition because each time we had an expert group of 5 days, we would spend 3 days arguing about definitions. And as a co-chair, I was becoming very frustrated about that obsession with definition. It's a very European way of looking into law. You define and then you look into the rules. But at the same time, I must say that some of the definitions were instrumental in building a consensus with states. Particularly some of that were less consulted, like the Russian Federation and the Chinese. Then you have the section from B to Y, I think, or X, where each of the section look into both of the general principle of international law of that particular topic, if we can say general protection of civilian aircraft, and then it looks into the particular rules for air warfare. Okay, so there is always treating in a dual way. One, the general principle, and that's where the commentary is very interesting, as you will see in a month, that there's a real discussion of what is the latest debate on these general principles and how they apply specifically to air warfare. Now, in terms of example, if we simply want to go into it, I suggest that we look into for example, the issue of collateral damages. And we know how this is a contentious topic. So if you want to look into the Rule 14, for example, okay? The Rule 14 talks about you know, how we measure collateral damages. And we know that this is a topic of hotly debated in every conflict we are dealing with. And this is in the section on attacks. And the Rule 14 talks about, evidently, the concept of proportionality. and look in particular to some points of the debate. For example, what is a direct to indirect damage that can be looked into? It reads, an attack may be expected to cause collateral damage which would be excessive in relation to the concrete and direct military advantage anticipated is prohibited. So it's purely additional Protocol 1 language, but then it's being debated as the distinction between direct and indirect and reverberating damages. And particularly to air warfare, all the discussion to what extent can you target military objective, and it's one of the next point I will look into, that are not purely defined as contributing to military operations. To what extent we can enlarge the military objective, and then to what extent can we still measure the proportionality of damages caused to assets that are not in that list of military objective. There was an agreement that purely indirect effect should not be should be calculated in the proportionality, but it has to be remote. So the reverberating effect, for example, attacking a target that destroys the electricity grid, that prevents the hospital to function, that prevents the provision of services, of primary health care, that prevents, therefore, create additional morbidity, etc. You have to limit the scope of proportionality. A second point, as I mentioned, is the military objectives and the definition of military objective that you can find in Rule 1, letter Y, and in Section E. This is also has been a Section E, Rule 24. This also has been a topic of a lot of debates within the group. As I mentioned, of what is to be considered a military objective and what type of connection can we expect between the objective and the military effort. And of course, starting from additional Protocol 1, we clearly see that assets that are by nature, purpose, or location can be targeted as military objective, but there has been discussion, for example, on war-sustaining assets, being economic assets or financial infrastructure, etc. To what extent these assets can be considered as targetable, and the debate within the expert community of what is the limitation, the actual limitation in interpretation of additional Protocol 1 rule applicable to air warfare. Evidently, because the scope of attacks, because of the expansion of the battle space in air warfare, these type of questions arise very quickly. The next point is Rule 8, for example, on the absence of an affirmative obligation to use precision-guided weapons. Also, it has been a topic hotly debated. That is, to what extent a state who has precision-guided weapons has an obligation or not to use such weapons. There has been days of discussion among experts on this issue, and there has been a consensus that, in fact, we do not have in current international law an obligation to use precision-guided weapons. Rather, precision-guided weapons may render an attack that would be indiscriminate or impossible to keep within the realm of proportionality more acceptable. Okay, so it's particularly related to urban warfare. The use of precision-guided ammunition expand the list of targets, because with such weapons you can better discriminate between lawful target and civilian assets. Moving on, and I have several of these, but I will maybe add one or two. Human shield. Again, a topic hotly debated. Rule 45, who talks about all the various interpretation that relates to human shield and all the discussion we had between voluntary and involuntary human shield. international law, positive law, talks about the prohibition of using human shield. Talks about the positive obligation of precautions, both from the attacker's side and the receiving side, to distinguish, to locate military assets away from civilians and civilian assets. Yet we know that in practice, human shields are being used. So what is the consequence, the legal consequence of the use of this shield? And there has been various interpretations that have been discussed, particularly pertaining to voluntary human shield, where you have individuals who voluntarily will locate themselves on a rooftop or close to a military objective with the purpose of inferring on the proportionality analysis, of increasing the political or legal weight, burden of attacking this target. What is the consequence of this voluntary human shield? Are these people directly participating in hostilities, therefore are targetable without any consideration to proportionality? Because once they directly participate in hostilities, they are, the immunity against attacks is being lifted. Or on the contrary, if they are not participating in hostilities, are they protected the same way as any other civilians in the area? Or does their presence affect the proportionality analysis in a different way? Do we have two measures when we look at civilians voluntarily participating in human shield schemes? Is the proportionality analysis being relaxed by such practice? There was no consensus, but these topics have been looked into and have raised a lot of anxiety among the experts, because it was seen that the manual, on one hand, had to come to an agreement. We had to come with a line, but and the failure to do so would open the door to abusive interpretation. But equally, there's no consensus among states about such interpretation. So that is to say, and I think I will leave the floor to the other panelists and to your questions. That is to say, the purpose of the manual here is twofold. One is to, as in 1923, is to present an updated collection of international legal rules applicable to air missile warfare. And I think that, it's up to the legal community to judge, but I think that 5 years of work in that area has demonstrated that it was possible, and we came with this set of 168 rules. But the second goal here was to recognize that current international law is a subject of debates. And debates are extremely important. It's simply healthy to have debates, even about issues that may have dramatic consequences. It requires responsible debate. It requires engaged debate. It requires expert debates. But we shouldn't live under the impression that universality of values requires universality of norms and requires universality of views. On contrary, the practice of international humanitarian law in concreto is made of diverging views, is made of conversation among professionals, being the commander and his or her legal advisor, being made of coalitions engaging on issues of norms guiding detention or on how to address grievances. That is, international humanitarian law is about conversations. And we hope that this exercise will provide a baseline for this conversation. Because this is where I would agree with some of the scholars that came to the project with a serious level of anxiety about us going below some international standards, particularly Additional Protocol 1, because major air power are not party to Additional Protocol 1. So there was an anxiety about some scholars that we would go back pre-1977 because we would admit that some of these rules are not necessarily applicable in current air and missile warfare. But at the same time, there was a recognition that this conversation has generated much clearer boundaries and areas of agreement that we believe in terms of planning, in terms of training, and in terms of legal discourse will provide a baseline for further development of international humanitarian law. Thank you very much.
I'm just going to take the microphone and launch in. My name is Ken Anderson, and as Dick said in his introduction, I'm a professor at American University Law School here in town. And I come to this with a very particular concern, which is that while both Jane and Claude and others have been working intensely hard in many different conference rooms and all sorts of different places in endless meetings and discussions and debates, I appear to have been at the beach. And the reason I say this is because there's something very peculiar about walking into a discussion like this where I've not done any of the heavy lifting or hard work or shown up at the meetings, but think at the same time that really the most important thing that I can offer is to actually criticize. But this sounds very ungrateful, I guess, or rude. So you're going to forgive me in advance for raising critiques of a process in which I skipped all the hard work myself. Now, let me approach this from sort of two different directions. One, I guess I would say, is a sort of exterior critique about the process, and it makes me very uncomfortable to sort of raise these issues, because this is the leading group of experts in the world, without any question about that, and it has gone out and searched harder to try and get the input of parties who otherwise might not be very interested in intervening in this process, such as the government of China, the Russian government, I mean, various groups that might actually have very strong feelings about this but wouldn't necessarily be interested in weighing in. And so this group has done more than I would say any other group, and certainly in my experience in this kind of process and going out and attempting to solicit exactly that sort of input. At the same time, the nature of this process is one that I would describe as having a fundamental collective action problem. Namely, that despite and without there being anything I think that you can actually do about it, despite every best effort that is made in order to solicit the input of the parties that are relevant to this, there is still a fundamental problem that the party that matters is the United States, and frankly, Belgium is not going to engage in air warfare. Germany is going to engage in very little air and missile warfare, if at all. The countries which contribute the most expertise, and undeniably the most expertise, in most cases are not countries which are in fact going to participate in the actual activity. And so there is built into the process, despite every best effort, and I mean that in every conceivable way, there is still built into this process a gap between the kind of expertise that can be brought to the table and the actual state practices of the parties who are in fact participating. So there's a collective action problem in which there's a party that one believes will listen at least to some extent to what one is saying, and that is the United States, and yet it is not party to Protocol 1. And there is a set of parties where this process has done a magnificent job of seeking to draw their views in. China, Russia, some other places. And yet, I at least have very severe questions about whether in an actual armed conflict those rules would be followed by those parties. And third, there's a set of non-state actors in which I think it would be remote to say that they have any intention of following any of these rules. And in that sense, the rules become a one-way ratchet on one side, which, granted, they're always obliged to follow those rules, etc., but it does have an impact on how they're stated here. All right, so that's an external critique, which essentially raises a sort of collective action process problem, which I don't think I don't think that this process could have done anything more humanly possible to try and draw in the parties. It's built structurally, I think, into the nature of the problem. Now, let me move to something that starts to approach an internal critique of the rules themselves. And I have not been able to see the commentary up to this point, or have not actually had a chance to read it. So I'll look forward to reading it, and it is perfectly okay to tell me that I haven't understood something, or to tell me that it's in the commentary and that I'm only looking at this on the basis of the black letter rules, and that the commentary, in fact, is the much more important part of this. But here's my sort of weird sense. On the one hand, I look at this as somebody with a fair amount of experience from the standpoint of what people operationally do, and think, this kind of manual is really magnificent because it winds up going to what commanders on the ground need. They need practical, straightforward, not incredibly hedged up language that tells them in a pretty straightforward way, without a huge amount of legal hedging, what the rules are. Okay. And that process produces manuals which tend to be, I would say, most useful to officers and to their lawyers in the field, in the planning of operations, in the planning of targeting, and all sorts of different ways. And I sort of think of that in my professorial life. I'm normally a business law professor. I'm about to go teach a class on venture capital and private equity. And I sit and I think about this from the standpoint of if this were presented to me as a contract, and I think, yeah, this is kind of what you're looking for, a pretty practical blueprint to how you want people to behave in various ways they can look at when they're planning operations on a going forward basis. Then, unfortunately, I put on this whole other hat, and I say, but you know, one of the problems with this is that's not, in fact, how in the world in which we live today legally these things get used. This is a litigation document, and from the standpoint of particularly the one state that actually has to worry about what the legal consequences are, as a litigation document, I have to look at it in a whole different way. I have to look at every word and think, how might a judge 5 years ago in an international tribunal, for that matter, a US district court judge in a civil ATS case, how might a judge in the United States look at these particular words and interpret this on the assumption that every word of this was negotiated with the anticipation of litigation in mind? Okay. So that when Claude tells me, and I believe him utterly and completely, that this process is intended to start a conversation and to serve as the beginning point, and that we need these kind of conversations, I agree with him 100%, and I also look at this and think, this is going to wind up in court. And then I have to look at it from a completely different standpoint and think to myself, am I really protecting people in ways that I think that they anticipate that they are being protected, if one looks at this as if one is weighing every word as though it might be interpreted by a court in the way which is least favorable to you. So let me give a couple of examples of this. Some of the issues that arise here are issues that go to the question of long-standing issues that have arisen around the interpretation of Protocol 1, objections the United States has had for a long time. Those are going to be built into this thing just in the nature of the process. I mean, there's kind of no way around that because there's just a gap between what the United States has signed up to and what other folks are signed up to as well. Then there's a set of rules that I think in many respects are a magnificent step forward, which are the rules that apply to things like how you deal with civil airliners, how you deal with civil aviation and all of these things where there isn't really an existing body of law. And this, I think, I mean, there's an existing body of law, but nobody's written it down in a set of usable rules. And this, I think, is a huge step forward. And then finally, there's a set of rules that I guess I would think of as being an advance in some way on concepts in additional Protocol 1, but that I would also describe as many of the most controversial, and these are the ones related to direct participation in hostilities. And that those rules wind up taking steps forward that it would be very, very hard for me to see the United States agreeing represent either the law as it is at this moment or a direction that the United States would like to see it to go. I'd be interested to find out if the US government thought that and to see that in its upcoming manuals. Let me, because I know I'm actually running out of time here, but let me bring this down to one set to give you an example of what it is that I mean by the problems of litigation when one is looking at every word. I look at the section that deals with feasible precautions, all feasible precautions. So, for example, I look at the general rules at 32. Constant care must be taken to spare the civilian population, doing everything feasible, all feasible precautions. And then at other points, so I've got three different uses of the word feasible there. Sometimes it says all feasible precautions. Sometimes it says doing everything feasible. And sometimes it just uses the word feasible. Now, when I put on my lawyer hat, I assume that these are the most sophisticated experts in the world, and they could not have drafted this. In fact, I don't believe that they would have drafted this without thinking to themselves the level of feasible precaution that they mean by this. And as we've seen in the debates over the Goldstone report, this is exactly one of the questions. What does feasible mean, and what does everything feasible or all feasible mean in these circumstances? Those kinds of questions will get litigated. And unfortunately, if that's the case, then I think that the parties that actually anticipate that they could be on the receiving end of that kind of litigation are going to have to take a view of this which is vastly, vastly tougher from a lawyer's standpoint than anything that can be taken into account on the basis of a sort of friendly and we're all in this together conversation, because it turns out that when you're actually in front of the judge, you're not. And I'll stop there.
Well, thank you very much, and I appreciate the opportunity to come and participate in this with Claude and Ken. First of all, I do have to say, when I was back on active duty and when I was working with the State Department, I always had to start every presentation with my remarks do not represent the views of the U.S. government or the Department of Defense. And now that I'm not on active duty and not working for the government, I still have to say that. So, because I'm afraid people might make the connection. So these are my own remarks. And I participated in this project in my personal capacity to the extent that one can do that when one is still working for the U.S. government. And I do want to say that I really appreciate all of the work that has gone into the drafting of the commentary and some of the remarks that I'm going to make. In fact, I hope that many of the remarks I make will turn out to be unnecessary, because the issues that I raise hopefully will be improved and corrected in the actual final version of the commentary that we see. But and so I appreciate all the work that went into the commentary. I will say that, at least for myself, when I first started this project, I understood that we were going to be drafting both the black letter rules and the commentary as a group, and that we would have an opportunity to actually draft the commentary. I understand the impossibility of doing that with the 30-something, 40 experts that we had involved. But certainly, and I can't thank Ken Anderson enough for his comments on the litigation issue. That was always at the top of our minds, with both the black letter rules and the commentary, as we looked at, how are people going to take this manual and how are they going to use it? Because while I don't disagree with Claude that international humanitarian law is all about the conversation, or that current international law is the subject of debate, that's true. But the bottom line for those of us who are or were on active duty is that, despite what the F-16 pilots said, we are responsible, our military is responsible for complying with the laws of armed conflict. We have to comply. And it's not a matter of debate, it's a matter of what our rules tell us we have to do and what our international legal obligations are. And so that's one reason that we wanted to focus so much on a restatement of the law, not on a progressive development of the law. But I'll also point out that I guess one of the things that is sort of mitigates the concerns there is that truly every country has to decide what law is applicable to them. For instance, the San Remo manual on the law of armed conflict at sea, the U.S. Navy does not use the San Remo manual. The U.S. Navy has our own naval warfare publication, 1-14 Mike, a very mellifluous title for a publication, but anyway, NWP 1-14 Mike is what our Navy uses when we need to know what are the rules of naval warfare. And so my goal or my hope is that other countries would take this air missile warfare manual and look at it and say, okay, this may apply to somebody, but it certainly doesn't apply to us, and this is not what's in our treaty obligations, and it's not what's in international law as we understand our customary obligations to be. And our soldiers and sailors, airmen, Marines, and Coast Guardmen have to follow the rules that they are given, not what is in this manual. Nevertheless, I agree with Ken that there is this concern that all of the proliferation of courts, international tribunals that are developing will start using texts like the Air Missile Warfare Manual as a, quote, source of the law. Which brings me to one of my concerns with the commentary, and that is the sources that the commentary says they're using as sources of the law. The last draft of the commentary that I saw said that one goal of the commentary is to cite treaties and other official instruments, in parentheses, such as military manuals, as well as relevant case law. Well, 2 points on that. First of all, there's a question as to the extent to which military manuals are actually official instruments of a particular government that represent the law that is applicable to that government. Our NWP 1-14 Mike, we believe, represents the law for our Navy, but that doctrine, it is a joint publication. It has been approved through DOD, but DOD is coming up now with a new law of war manual, and so we're going to have to make sure there aren't any contradictions between the NWP and the DOD law of war manual. I personally know that when we were involved in the EP3 incident back in April of 2000, there was an absolute contradiction between the military manuals in the People's Republic of China that talked about the rights of an aircraft in distress. There was a complete contradiction between those manuals and between the official PRC position on what the rights were of an aircraft in distress. And so you have to be really careful when you're looking at military manuals. In fact, the ICRC Customary International Law Study actually cited a draft manual, for Pete's sake, as evidence of state practice. So you've got to be careful about, you know, because something is doctrine, and that's another point, because something is doctrine and because we military can be held liable for not following our rules of engagement, does not mean that we're engaging in those rules as a matter of law. It may simply be a matter of policy, and often our publications don't make that clear. And so, you know, you can't say just because it's in a manual, it therefore is, as a legal matter, a legal obligation of the United States government. The other point that I wanted to make about the sources is that and I hope this is corrected in the final version of the commentary, but the commentary cites to a number of non-legal sources as, quote, sources of the law, such as the San Remo Manual, the ICRC Customary International Law Study. There's this San Remo sort of booklet on non-international armed conflict that was written by 4 or 5 people who, I mean, I respect them all, they're great scholars, but they just wrote it. And there was even one place in the commentary where they suggested that they ought to cite this Montreux document on private military security contractors, which is also not a legal document. So, I mean, if you're looking at the commentary and it says the source of this law is the Montreux document on private military security contractors, that can't be, because that's not a source of the law, just as the San Remo Manual is. Anyway, so that point, a couple of other problems that I saw with the commentary that I hope will be corrected, and that was a tendency, as Claude has very graciously explained, there were some real discussions and disagreements among the experts on some of the text of the black letter rules, but we agreed on the black letter rules, and I think we did a fairly good job on getting the rules fairly solid. But oftentimes in the commentary, I find that the drafters have introduced new rules that are a gloss on the black letter text and that completely sort of change. You know, if we had been able to agree on what those rules were, they would have appeared in the black letter text. And so for the drafters to then add them into the commentary as with qualifying words like it is prohibited to do this, it is required that you do that, you may not, you must. If you see those words in the commentary, then to me that's an indication of an unofficial black letter text that we couldn't agree on that now is appearing as a normative rule in the commentary, and that just can't be. You can't have normative rules in the commentary. And I certainly agreed with Claude's frustration about the definitions. We spent so much time on the definitions, and all of us kept wanting to move on to the substantive parts of the latter part of the document and of the black letter rules. But my feeling is that the further you go along in the text and in the commentary, there tends to be less rigor, if you will, in the academic discussion of the rules, and particularly when you get to areas like the environment, the sections on cultural property, the sections on humanitarian relief. I think because we've spent partly because we spent less time on reviewing those rules, the commentary tends to throw in a lot of these ideas that none of us agreed on, that none of us accept as being the law. And so I'm hoping that those will be taken out of the final version of the commentary because they were very controversial subjects that we simply could not agree on for the black letter text. And so it's not, I don't think, correct that they should appear as sort of normative rules then in the commentary. There was also, I think, there's a tendency sometimes, as Ken pointed out, to use sort of imprecise language, and just one specific example was Rule 97, dealing with the starvation of civilians as a method of warfare, is prohibited. That's a pretty clear rule. The last version of the commentary says what that means is that you cannot cause the civilian population to suffer hunger or otherwise affect its subsistence. Well, affecting the subsistence or suffering hunger is not the same thing as causing starvation. And so if that kind of imprecise language appears in the commentary as a gloss on the black letter rules, then it really detracts from the black letter rule and causes confusion. If in fact one of the goals of the text, of the black letter text is, as I understand it, after these 6 years of working on it, is that we do provide a clear, concise, accurate statement of the law, then if the commentary confuses the issue, that certainly doesn't help the military commanders or the lawyers that are advising them. There was also a couple of attempts to create sort of rules or rules by analogy or by implication, and the text sometimes does that. In the commentary, well, it says, well, this rule applies to medical aircraft, but by analogy, we can apply it to civil relief. Well, I mean, that just doesn't work in international law. If you're going to be held legally responsible for something, there has to be a treaty basis or a customary international law basis. You can't just, by analogy, apply one rule meant to deal with a very particular situation to a completely different situation. The reason I'm making these comments is because I am concerned, and I do want to be sure that the commentary comes out in as solid and as clear and helpful a manner as the black letter rules have turned out, I believe that are. And so again, my comments are not to criticize the whole commentary, but throughout this process it has been to try to give thoughts and actual concrete suggestions to the drafters to help improve the product and not just to cut it down. So based on comments with Claude before this meeting started, I think the commentary is going to be much improved when it finally does come out, and hopefully these issues that I'm talking about won't even be relevant. Thanks.
Thank you.
Claude, would you like a couple of minutes to comment on both of the commentators' comments
Yes.
and before we open up for questions?
Very good. And I must say, I cannot necessarily respond to all the comments, but I'll make some points here to open the discussion. Ken's point about the weight of state practice, U.S. state practice against, let's say, legal expertise in other countries, I think it's somehow unfair to the legal practice in the U.S. And I think, if I may say, Jane, your comments illustrate that point, is that there is a wealth not only of state practice, but of legal thinking and critical thinking about the law in the US that was one of the foundational pillars of this initiative. And if we have, I may say, some romantic scholars in other countries that would see the law from a different light, the American experts who participated in this process, particularly those who, in addition, had a role within the Department of Defense, were always there to bring us back to the mission. And this equilibrium in the process was very important because as a chair of the process and Professor Dienstein as a co-chair and the project advisors, we're often between two views or several views, and we're trying to build a consensus. And a consensus is always some kind of below everybody's views. It's trying to manage different perspective and find a wording that can rally the unanimity, hopefully, or at least the majority of the participants. But this is where the legal expertise and method from the United States played a critical role. To illustrate my point, we often had, and I must say it was very interesting, we went to all these places, all these conferences all over the world, and when we were sitting in the room, we never attribute seats, okay? We simply said, myself and Yoram Dienstein would sit, and people would sit normally where they would sit. And ICRC delegation, if I may say, was always sitting in front of the United American delegation. And then there was a joke about this. That is, there was actually a dialectic. There was a dialogue between different views, not only from the US and from the ICRC, but from different sources that questioned the notion that there was somehow an uninformed international view. I think that the views in the manual have been informed by US legal practice in a major way. Extra efforts have been devoted, even after the end of the drafting committee's work, to circulate once again the result with individual to look at it once again, just to verify and then to be put on notice that indeed we may not have fulfilled all the expectation that was put on the project in reaching the right balance. So that is to say, US participation in this process has been critical to the quality of the product, and we're extremely glad about this. Now, about the litigation. Well, there was litigation and there will be litigations. The fact that this manual becomes part of the legal material being brought into litigation raised 2 points. One, I don't think we could expect such a manual to play a major role, as the San Remo manual is not playing a major role in US litigation. So the model applied to the San Remo manual also demonstrate that it's not such a critical contribution, but even if it does provide, let's say, source of doctrine, well, we should celebrate that, because precisely it provides more clarity. It provides an input for judges to take the right decision. Now, if lawyers want to argue pro or against some of the conclusions, there's a commentary for them to look into and questions the authority of these experts or of these sources. So the fact that we have a more profound discourse on international law may be may reflect on litigation, but I think it's a good thing. It simply will make the decision of the judges more informed about the status of international law. Now, the point about the authority of the manual, because as you can see, there's a certain level of anxiety about the wording. You know, if starvation is you know, hunger or affecting the health status of these individuals. Yes, there are discussions about this, and the drafting committee, based on the rules adopted by consensus in Bern, has tried to do its best to reflect that debate. It's up to governments, scholars, to criticize the manual, to say, well, in fact, starvation is a much narrow perspective. Or, no, the perspective of the manual is too narrow. International law prohibits a larger understanding what starvation is about. The point here, it creates a baseline for these conversations. And the manual is in a world of mirrors, you know. It's the reflection of international law. It's a reflection of international legal debate. And of course, within these mirrors, there are diversities of views about what are the acceptable sources for this debate. The customary law of the ICRC, the Sanremo manual, different sources of doctrine that evidently do not have a normative value as international legal treaty and other sources of positive law. But yet, they play a very important role in the discourse about international law. And some of the reference that we find in the commentary makes reference to these positions. For example, if the ICRC lawyers made a very strong point, being on DPH or the environment or, you know, referencing their own sources, well, we believe in some cases, not in all cases, I can reassure you, we believe that it was only fair for the readers to know where that information came from. Because if the doctrine is better explained into the ICRC customary law study, it will inform the practitioners to go look into the study and make their own assessment of the legal authority of the ICRC study. I think the debate about the legal validity of DPH, or the study on the direct participation of civilians or of the customary law study, is above and beyond the manual on air missile warfare. And it's a debate that will continue. We're looking forward, as we're finishing this initiative, to have a dialogue on methodologies, because I think this kind of trench warfare, if I may say, on manuals and the legal validity of these sources, I think that the demand from practitioners for clarity requires that we somehow create that space where this conversation may take place without being, so constrained, being by the fear of litigation or by the fear of liabilities on what sources we cross-reference, that we can see that the purpose of the manual is not to finally state what is the law, but to create a more informed debate on particular applications of the rules.
Thanks, Claude, and to all of our panelists. Let's give them a big hand for their presentation. I think we've demonstrated that one of the purposes of the air and missile warfare study has already come to fruition here because the debate has started. The discussion continues that HPCR and the Alabama project intended to get going, but it's continuing in a public forum now instead of in the more confined forum of groups of government experts and exposure to governments. So we at the Libre Society appreciate that that HPCR and the commentators are willing to come here and engage in that debate. But now is your turn to foment that debate and ask questions of the commentators. So we're taping this today, so I'll hand out the microphone so that we can record your question. Questions?
Gary Solis, currently of Georgetown Law, Libre Society member. I presume that the commentary was written by a committee of the experts. If that is correct, how long did they have to do it, and was it completed after all of the expert meetings were concluded, or was it written contemporaneously, or how?
It's a very good question. We were hoping that when the manual was adopted in the 15th of May, the black letter rule that is, on 15th of May 2009, we would have a complete commentary, because many of the participants to the expert group argued that they could not consent to the adoption of the manual without having a clear understanding of what is in the commentary. Because many of the rules were interpreted in the commentary. So our primary goal was to do this contemporaneously. But because each of these group of expert meeting provides so much material to the commentary that we had much more work to do even when the manual was adopted in Bern in 15th of May. So there was a 6 months, if I may say, time frame where we had to catch up, and the commentary has been finalized in January, and now is being just circulated within the drafting committee, which is composed of 6 of the expert, of the group of expert, and will be made public in a month.
Hi, I'm Paul Walker. I'm with the Navy JAG Corps, currently at GW University, working on a LLM. Just from a glancing perspective, I find it interesting the comment that Mr. Anderson made regarding the lack of U.S. participation or lack of U.S. reflection, and Admiral Dalton's comments regarding the sources, because given the stated purpose, the direct participation hostility section refers to a great deal of things that seem to be even beyond lex ferenda in many respects. And I mean, when you sit down and do black letter, I have a real concern over the credibility of a document like this. When you say you're putting black letter and you have a definition of computer network attack that, to the best of my knowledge, comes from U.S. doctrine. I mean, the source for that is U.S. warfighting doctrine, not even legal doctrine. But that definition itself conflicts with what arguably could be customary international law attack under Article 49, which you shorten somewhat. But, I mean, that sort of problem cuts across all those things, because they are using U.S. doctrine. They're using it as a source. It's the wrong source for black letter law that doesn't exist. That would be my comment, just looking at it, beyond the problems with the expansive nature of the direct participation hostilities. I mean, to employ communications. Anyway.
Do you want to comment?
do a few, maybe? Or
Okay, some other questions?
Stephen Anderson, thank you very much. I'm interested, it's a question of process and content. You stated that this was supposed to be a statement of the law as it exists. And so my question is, when you face situations where the laws in one area may conflict with manuals elsewhere, what was the process for deciding what you would set forth as the statement of the law? Was it the lowest common denominator? I know you'll deal with this in the commentary, but how did it actually affect the black letter law and the actual statement of the law?
Okay, let's take a couple more. Some questions from the back here?
Hi, Ken. Thank you so much for a great presentation, because it's very exciting that you guys are involved in this. I think just sort of following up on the questions and comments made by the gentleman behind me. I think that don't you think that parallel that that it's also a question of the quality of intelligence that, I mean, we're concerned about the quality of the manual, but, it's so many of these things are also a consequence of the intelligence that, and I wonder just how much work is being done on that side, so that, which would then strengthen, this manual.
Samir, you don't mean smart people, you mean the intelligence community, is that? Okay.
Absolutely.
But they have law. They have a lot of lawyers.
These all sound sort of addressed to you, actually.
Yes, but there's some, maybe it may underline some of your critiques, so you may want to emphasize some of the points.
Should we take these three and sort of maybe before I forget what the first one? Let me just say, I mean, I think actually, in fact, these are really mostly questions for Claude, but let me start with Samira's point about intelligence community and questions there. Yes, I think that this is actually a very big question about this because, for example, when I see in the black letter rules when it talks about no use of civilian aircraft, I think I know what that means from the definitions and haven't seen the commentary, but clearly questions about CIA use of drone aircraft, does that count as military under this or not? I'm not really quite sure. And I think that there's an emerging debate over the question of whether all of the activities and use of force engaged in by the CIA under U.S. domestic law, whether that all counts as military or armed conflict. And so I think there are questions about how that will relate with those issues. And then I guess I think that there's also a broader question of sources that I think both of your questions are going to, and which I think Claude is really the person to respond to it. But I guess I would say, Claude, the phrase that you used is sort of a stunner to me, actually. The customary law of the ICRC? Nobody is a bigger fan of the ICRC than me, but I would not have described it as a source of law in that sense. And at the same time, think that if the purpose of the manual is what I think manuals should be about, which is for guidance of people largely in the field, including their lawyers, then that's all great. But I want to know whether when this comes into an international tribunal or this comes into a U.S. court or this comes into some litigation somewhere, you're going to stand up and say, this was just a conversation, this is not a source of law. Whew, that was mean. Okay.
Okay. I'd like to answer to this comment and to the question first by saying that from the early stage of the initiative, the purpose was here twofold. One was to be a reflection, a mirror of existing international law. And when we say international law, looking from state practice, well, it brings different images, and some of these images are contradictory. So that's where comes the second goal, is how can we improve clarity of a fragmented image? Okay? Because evidently, even within the US legal system, there's contradiction. So if you put this between the UK and the US jurisdiction and other air powers, you become to an increasing number of disconnect or contradiction. And the purpose of the manual here is not to collect these discrepancies, but is to provide a narrative of the international law applicable to air missile warfare for practitioners to have a clear understanding of these rules. So this is a didactic effort of helping practitioners, and maybe not at the US Navy War College, but maybe at the field level, maybe in coalition operations, where often they have, they may not have the legal support or doctrine or framework that we can have here in the United States. Maybe the concern is not so much litigation, but to provide a clear legal framework for operators. That is to say, the purpose of the manual here is not to complement US legal doctrine. It's much more to provide a legal framework for operations that may or may not engage US operators. So, yes, there are issues of contradiction. I don't think they cut across so much of the manual. There are, let's say, the bone of contentions could not be avoided. So, direct participation of civilians, precautionary measures, military objective. I mean, I've mentioned some of them, and we're not afraid of them because they are central to the legal discourse. These bone of contentions drive the legal discourse domestically in front of courts and in front of international courts. Therefore, the contribution of the manual and of the expert, and I'll come how we try to manage this point, but the contribution here is to provide a baseline of an opinion of a group of experts. What the group of experts did here, and we selected them for their capacity to dialogue on these issues, to establish a conversation. And I must say, it revealed among them unknown skills of engaging in conversation, that they are able to come to a common understanding and agree. The manual was adopted by consensus in May of last year, so nobody got his or her arm twisted in saying, yes, in terms of black letter rule, this is what I think is the current status of international law applicable to air missile warfare. And that's the key point. We at HPCR do not take a substantive views of any of the rules. We do not say, oh, this is the right rule, or this is the authoritative rule. No, we're saying this is an exercise led by the group of the best experts we could find in the world, brought around the table, encouraged to dialogue and to come to a consensus. And that's what we got out of this consensus. To be explained, the differences, the divergence, the difficulties, the sources, the cross-references in the commentary. So the point here, and to become more specific, if I may, about method, yes, there was and Jane can relate to that, there was a lot of energy and discussions and diverging views, and, you know, so many experts went around walking in the room saying, how can you do this? Others threatened to walk out and did walk out and come back. I mean, it was, especially in the early phase, it was a, how can I say, a circus. Okay? Nobody thought it would work because there was enormous anxiety about getting to a common view. But a fascinating moment was when, you know, in this first phase, when you have individual experts coming with their paper, of course with their views, and being open to discussion, and the other experts putting their brain into that paper and trying to solidify that view with immense respect, okay? Because they could have destroyed the other view. And we know there's sharp minds there, okay? And they could simply mince many of the position, which would have created division, not consensus. No, there was a common sense of purpose that the world of practitioners and legal practitioners need a manual, need this clarification. So we need to put our brains together to get there. But even with that sense of common purpose, we had a lot of shouting and disagreement, and we had to bring this down to the rules you have there, and then to a set of commentary that reflects the disagreement. We had a rule in the discussion that only in extreme circumstances we would go for a vote. And we said that under this rule, if we get the majority plus one, the rules make it to the black letter rule, and the diverging views be put into the commentary. However, we also said that if we have a diverging view of two or more experts, that view makes it to the commentary anyway. So it was fair even for the smallest minority, or tiniest minority, to be reflected, because we respect opinion, but it has to be not a fantasy of one expert. It had at least to get two. So the coffee breaks were very active. But in fact, we voted once. And almost everybody regretted that vote. Once on one article, and I even don't remember which one. Okay. And everybody regretted that moment because it was, after 5 years, almost a failure. Failure of the group to make that extra effort. But yes, at the last meeting in Bern, there was moments where some experts in group or individually threatened to walk out and say so much effort. I mean, there was a lot of negotiation, but this is where we are. And I think, with all due respect for those who will have to litigate with that text, and I don't expect them to call me to be a witness, I think this product is a positive contribution, and I'm looking forward to those who, like you, can go and with the scalpel and simply cut through it and says, well, actually, there's a contradiction here. Expert didn't do a good job. Well, you'll have to deal with the expert afterward, and some of them are pretty sharp. But fine, this is what it's supposed to be. It's supposed to be an upgrade from this confusion and this kind of mushy consensus that we all agree about the rules, where in fact we don't.
And Dick, if I could.
Sure, go ahead.
Yeah, I'd just like to address a couple of those. First of all, you do have to look really, really carefully at the black letter rules. Because with the DPH issue, for example, this was one of great discussion and debate. But the way it came out in the end says, subject to the circumstances ruling at the time, the following activities are examples of what may constitute taking a direct part in hostilities. That's the only way we could reach any agreement on that, was to say these are examples of what may constitute subject to the circumstances ruling at the time. So this is not one of those rules with a prohibition, you must, you cannot, da-da-da-da-da. With respect to your question, sir, about the disagreements, I mean, clearly the big issue, one of the big issues throughout the whole thing was the U.S. and Israel, non-AP1 states, and then everybody else in the world, parties to AP1. One of the ways that we found to help address some of those issues was that back in 70-something, when Mike Matheson from the State Department published, and I think it was the ASIL and the journal, or at a conference. Okay. Where Michael Matheson, after a study by many members, some members within DOD and coordinating with State Department, came up with a list of what he said at the time was reflected, which parts of AP1 reflected customary international law. It's a very short list, okay? But at least that gave us some basis where we could say, even in our personal capacities, we could say, look, if Michael Matheson, and I'm fully aware of all the debates within DOD about whether the Michael Matheson article was properly cleared, blah, blah, blah. Nevertheless, we were able to say, this seems to be a fair statement of what the U.S. position was back whenever it was, and so that then allowed us to come to some agreement on some of these terms. But for many of the rules, it was just, as Claude explained, there had to be, that we wanted to have a consensus. We tried to word the language in such a way that we could reach consensus while still being faithful to our understanding, or at least my understanding of what the law really was. And with respect to the disagreements, and goes back to the concerns I have with the commentary, the DPH rule, I think, 29, is a good one. My concern will be if the commentary then just quotes verbatim the ICRC explanatory guidance, or whatever they're calling, interpretive guidance on DPH. If it just quotes that verbatim, then to me that really will detract from the value that we gained by putting that rule in there. The other point is that I think it's perfectly fair, and I agreed, as did the other members, that if there were experts, a group of experts who disagreed and wanted their views expressed in the commentary, that was fair. But it needs to be expressed in the commentary as the views of a certain number of experts, and not written in such a way that it looks like it's a gloss on the black letter text or a new rule appended to the black letter text. So it's how those views appear in the commentary that are going to be really important.
Do you have any other burning questions out there? How about you law students? I mean, the customary international law, the customary international law and the definition of it goes into this this process. It's kind of subtext in much of this conversation.
Do you have any questions about that? Sure.
Hi, Chris Icavella from Georgetown LLM. I just have a question for you. This is a consensus that's intended to start a debate internationally and not a set of legal norms that we have to follow. Then why does the title say Manual on International Law applicable instead of Manual of Suggested Legal Norms applicable to air and missile warfare? Because to me, this, like you said, this is a piece of paper that certain legal groups in this country and across the world will take right into court and say this is law. They violated this rule. It's a violation of international human rights underneath the ATS statute. So I'm just wondering if it is consensus and it's not intended to be followed by everyone, then why isn't there some mention of it in the title?
Let's take any other questions that are out there right now?
I got it. Yeah, Chris Birch, and actually with Defense Department, to follow up on Chris's question over there a little bit, there seems to be two goals behind this manual. One is to state black letter rules, and the second is to start a conversation. And potentially those two goals, to me at least, seem like their intention, I think in some of the ways Professor Anderson mentioned. So my question is, if assuming the United States, and particularly the US government, the Defense Department, the CIA, et cetera, want to engage in this conversation, what are the steps that they can take or they need to take to basically protect our CIA operatives, our airmen, et cetera, from some of these rules or commentaries, while at the same time still being active members in the participation and in the debate?
Any other questions out there? Okay, let's take these.
Thank you. I'd like to start with your question, and then I'll go to yours. I think there's various steps in which this debate will enter. The first one, as we expect, will be a critique of the manual. Its legitimacy, being the title, being the content, the origin, the experts, which I assume will take 1 year to simply get through, because it's a new text on the block. Who are these people? What is this text saying? And I expect this debate to be mostly academic. While at the same time, and especially from signals we get from being NATO or some governments, they say, well, actually, it's very timely, because we were looking for not a final text of what the law is, but we were looking for a point of departure for our own reflection on air warfare. And this comes right at this moment where debates are starting, legal doctrine will be developed, and especially in the context of coalition operation, where interoperability requires some kind of a third-party platform for these conversations to take place. Because as much as legal expertise from the US has been well studied, it cannot be the point of departure for some of the conversation to take place with allies. So I think the second step will be in that context of coalition operation, not of necessarily domestic dialogue, because I think Jane is entirely right. This is not the law governing domestic operation. The law governing operation has to be US laws, and the manual can only contribute at a sort of remote academic level to define what are US obligations in this field. Now, when I say that, people raise their eyebrows and says, well, but actually, this is not what you think, okay? We had this kind of agenda of influencing the interpretation of US norms. I don't think so, honestly. And I'll tell you why. The debate about the extent and scope of US norms being in court or in the court of public opinion, okay, is not a debate about details, not a debate of how do we look into voluntary human shield interpretation of proportionality. This is really at an academic level. It is about the legitimacy of the use of force. It's about the legitimacy of the use of some weapons. It's about the grand scheme, means and method of warfare, which are not detailed enough for the manual. Our expectation at Harvard is that we're going to get into problem not so much with US military practitioners, but much more with the human rights community, okay, that have, if I may use that term, Jing, using the gloss of this confusion of norms to expand the sense of obligation of the military, to play with some of this terminology, to say, well, this is international law. And now that we have a group of experts, which included professionals from the ICRC, stating more clearly what these rules are, it will be difficult for many of the protagonists of these debates, in court or out of court, to develop a sound legal argument. So that is to say, the steps, I see them threefold, to summarize. First, one of academics questioning, this new source on the block. Then coalition, getting very interested in material, legal material to feed legal doctrine discussion. And then at the third level, to see how, in the course of long-term discussion at the domestic level, how it will refine the arguments of protagonists, being from human rights advocates to government to the legislative, to define better some of their terminology. Now to come to the title. The title has been a topic of identity crisis, group therapy, everything went into that. And I tell you, that front page, you may look, oh, it's a front page. I'm sorry. Everything on the front page has been negotiated, okay? The date, the location, the name, the logo at the top, everything has been the subject of a negotiation. So that is to say, a lot of thought went into that title. And this is the consensus of the group to go with that title. Now, evidently, the title in itself may give a sense that this is international law applicable to air missile warfare. And it's unfortunate that the commentary took a few weeks too long to be there this afternoon, but there is a lengthy introduction that explained this point. And I wish good luck to any lawyers who goes to court with that without reading the introduction, because they're up for some surprise. Okay.
Do either of you want to make any further comments?
I think we'll cut it off here and offer the chance to finish up some of those hors d'oeuvres in the back, but also to continue this dialogue with the participants and amongst the group here over some refreshments. So one last hand for our commentators.